I woke up one morning to find construction equipment tearing up my property. The HOA was building a community playground on land I owned. They never asked permission, never sent a letter, just showed up and started digging. What happened next will shock you. I'm about to expose how I fought back and won against an out-of-control HOA. Stay until the end because the final twist changed everything. If you've ever dealt with a nightmare HOA, smash that subscribe button right now as Neighbor Wars HQ, where we expose the truth about property battles. My name is David, and I thought I knew exactly where my property lines were. I'd lived in Riverside Estates for 7 years. Quiet neighborhood, tree-lined streets, the kind of place where everyone waves at each other. Or so I thought. It was a Tuesday morning in March when my entire world turned upside down. I was working from home, on a video call with clients, when I heard it. The unmistakable roar of heavy machinery. At first, I thought it was just road work. Maybe the city was finally fixing that pothole on Maple Street. But the sound got louder. And closer. I walked to my back window, coffee in hand, and I couldn't believe what I was seeing. An excavator. A dump truck. 3 construction workers in neon vests. And they were on my land. Not near my property line. Not close to the fence. They were a full 15 feet inside my backyard, ripping up the ground where my garden used to be. I ran outside so fast I forgot to put on shoes. The foreman, a guy in his 50s with a clipboard, barely looked up when I started yelling. "What are you doing? This is my property." He glanced at his paperwork, then back at me with this condescending smirk. "Sir, we have authorization from the Riverside Estates HOA to construct a community playground on this parcel. If you have concerns, you need to contact the HOA office." I felt my blood pressure spike. Authorization? I own this land. You can't just build.
Here. The foreman shrugged. Take it up with the HOA, buddy. We're just doing our job. And then I kid you not, he turned his back on me and kept working. That's when I knew this wasn't going to be a simple misunderstanding. This was war. I immediately called the HOA office. You know that feeling when you're on hold and every second feels like an eternity? That was me for 23 minutes, listening to classical music while watching strangers destroy my property. Finally, a woman named Patricia answered. She had that syrupy, sweet voice that instantly set off alarm bells. "Riverside Estates HOA. How may I assist you today?" I tried to stay calm. I really did. "Hi. This is David Morrison at 847 Oakwood Drive. There's a construction crew actively digging up my backyard right now, and I need to know what's going on." Patricia paused. I could hear her typing. "Ah, yes, Mr. Morrison. The Community Playground Project. This was approved at the last HOA board meeting. The construction is scheduled to take approximately 6 weeks. Approved by who? I never gave permission. This is MY property." Another pause. "According to our records, the designated area falls within HOA common space. All residents agreed to certain easements when they purchased their homes." I nearly dropped my phone. Common space? I have the deed to this property. I've been paying property taxes on this land for 7 years. Patricia's voice turned icy. "Mr. Morrison, if you have concerns about the property boundaries, you're welcome to submit a formal complaint in writing. The HOA board meets on the 3rd Thursday of each month. In the meantime, construction will proceed as scheduled." And then she hung up on me. I stood there, phone in hand, watching the excavator tear deeper into my yard. My wife Sarah came home from work early after I called her in a panic. She's normally the calm one, but even she couldn't believe what was happening.
"They can't do this," she said, her voice shaking. "This is illegal. This is trespassing. This is, I know, I interrupted. And we're going to stop them. But here's where it gets complicated. And if you're dealing with an HOA issue right now, you need to hear this." That same afternoon, I drove to the county recorder's office. I needed to pull my property records, my deed, the original survey, everything. The clerk, an older gentleman named Frank, helped me spread out the documents on a large table. "This here," he pointed to the survey from 2016 when I bought the house, "shows your property line extending all the way to that cluster of oak trees. See these coordinates?" I nodded, taking photos with my phone. "Now, if someone's building on that land without your permission, that's a clear property violation. You might want to get a lawyer involved. A lawyer? Of course. Because fighting your own HOA wasn't stressful enough without adding legal fees to the mix. But I had no choice. I contacted 3 law firms that specialized in property disputes. The first 2 wanted retainers that would have cost me more than my car. The third firm, Morrison & Associates, no relation, unfortunately agreed to review my case for a consultation fee. The attorney, Jennifer Park, was sharp, professional, and blunt. Mr. Morrison, what you're describing is a textbook case of trespass and potentially adverse possession if they're claiming easement rights they don't have. However, fighting an HOA is expensive and time-consuming. You need to be prepared for that. I don't care about the cost, I told her. They're building on MY land. This is about the principle. Jennifer smiled. Good. Because we're going to need that attitude. First step. I'm sending a cease and desist letter today. Second step. We're getting a court order to halt construction. Third step. We're suing for damages, legal fees, and a permanent injunction. For the first time since this nightmare started, I felt hope. The
cease and desist letter arrived at the HOA office via certified mail the next morning. Construction stopped by noon. I thought maybe, just maybe, this would be resolved quickly. I was so wrong. 3 days later, I got a letter from the HOA. Not an apology. Not even an acknowledgement of the property dispute. Instead, it was a violation notice. According to the HOA, I was in breach of community covenants for failing to maintain my lawn because it had been destroyed by their construction, creating an eyesore with the exposed dirt in my backyard. Again, they're doing not obtaining proper approval before modifying the landscape. And here's the kicker. They were fining me $500 per day until the violations were corrected. Sarah read the letter 3 times. This is retaliation. This is blatant, obvious retaliation. Oh, it gets better, I said, checking my email. They've also scheduled a special hearing to potentially revoke our access to community amenities. The pool, the clubhouse, everything we've been paying for. But the HOA wasn't done. Not even close. A week later, our neighbor Karen, president of the HOA board, knocked on our door. Now, Karen and I have been friendly for years. Our kids played together. We'd barbecued in each other's backyards. I thought she'd be reasonable. David, she said, not quite meeting my eyes, you need to drop this lawsuit. You're making things very difficult for the entire community. I couldn't believe what I was hearing. Karen, they're building on MY property without permission. How is that making things difficult for anyone except me? She crossed her arms. The playground project has been in the works for 2 years. We've allocated budget, hired contractors, gotten architectural plans approved. If you derail this now, it's going to cost the HOA and by extension, all of us tens of thousands of dollars. Then maybe the HOA should have done a proper survey before they started.
Digging. Karen's expression hardened. The board has asked me to deliver a message. If you continue with this lawsuit, we will pursue every available avenue to make your life here uncomfortable. We have bylaws, David. Lots of them. And we can enforce them very creatively. It was a threat. Plain and simple. After she left, Sarah was furious. Did she seriously just threaten us? In our own home? Document everything, I told her. Every conversation, every letter, every interaction. Jennifer said we'd need evidence of harassment, and now we have it. Over the next 2 weeks, the HOA's campaign of harassment intensified. We received violation notices for our mailbox being 2 inches too far to the left. It had been in the same spot for 7 years. Our trash cans, which we'd always placed on the curb Tuesday mornings, were suddenly in violation of being visible from the street. They sent an inspector who claimed our fence needed repainting. Despite it being only 3 years old, we were cited for having unauthorized holiday decorations in April. We had a single potted plant by the front door. Each violation came with fines. $50 here. $100 there. By the end of the month, the HOA claimed we owed them over $3,000. But here's what they didn't know. Every single violation notice was evidence for our lawsuit. Jennifer was building a case not just for property trespass, but for targeted harassment and abuse of HOA authority. They're digging their own grave, Jennifer told me during one of our strategy sessions. HOAs have broad authority, but they can't use it discriminatorily. What they're doing to you while simultaneously not enforcing these same rules on other residents is textbook discrimination. How do we prove that? I asked. Jennifer smiled. I need you to document every house in your neighborhood. Take photos. Make notes. Show me that other residents have the exact same violations you're being cited for, but they're
not receiving notices. So that's exactly what I did. I spent an entire Saturday driving through Riverside estates with a camera. Mailboxes slightly askew, photographed. Trash cans visible from a street, documented. Fences with chipped paint, recorded. Holiday decorations still up, cataloged. By the end of the day, I had evidence that at least 40 other homes had identical violations to the ones I was being fined for, including, and this is the beautiful part, including Karen's house. Her mailbox was 3 inches further from the property line than mine. Her fence had more paint chips, and she still had Christmas lights wrapped around her porch railing. In May, Jennifer was ecstatic when I showed her the documentation. This is perfect, absolutely perfect. We're going to destroy them in court. The hearing was scheduled for June 15th in County Civil Court. Judge Margaret Holloway presiding. I'll be honest, I was terrified. I'd never been involved in a lawsuit before. The HOA had deep pockets and a legal team that probably cost more per hour than I made in a week. But Jennifer kept reassuring me that we had the facts on our side. Facts win cases, she said. Not money, not expensive lawyers. Facts. The courtroom was smaller than I expected. The HOA's legal team of 3 attorneys in identical Navy suits sat on one side. Jennifer and I sat on the other. Sarah was in the gallery, along with a handful of other neighborhood residents who'd heard about the case. Judge Holloway was a no-nonsense woman in her 60s who looked like she'd heard every excuse in the book. She reviewed the case files, then looked up at both parties. "Let me make sure I understand this correctly," she said. "The HOA initiated construction on land that Mr. Morrison claims is his private property without obtaining his permission or conducting a current survey." The HOA's lead attorney, a slick-looking guy named Richard Pemberton, stood up. "Your Honor."
If I may clarify, the property in question falls within an easement that was established in the original Community Development Plan from 1995. All homeowners implicitly agree to these easements when they purchase property in Riverside Estates. Judge Holloway raised an eyebrow. Do you have documentation showing that this specific parcel was included in that easement? Pemberton shuffled through his papers. The general easement language covers all common areas, Your Honor. That's not what I asked. Do you have a survey showing that Mr. Morrison's property specifically falls within the easement boundaries? A long pause. We relied on the original development plans, Your Honor. So that's a no. Judge Holloway turned to Jennifer. Counsel for the plaintiff? Jennifer stood, calm and confident. Your Honor, we have 3 separate documents that establish Mr. Morrison's ownership of the disputed land. First, the original deed from his 2016 purchase, which includes a professional survey. Second, a current survey we commissioned last month, which confirms the exact same boundaries. And third, property tax records showing that Mr. Morrison has been paying taxes on this specific parcel for 7 consecutive years. She handed copies to the bailiff, who delivered them to the judge. Judge Holloway reviewed the documents carefully. "Mr. Pemberton, your response?" Pemberton looked flustered for the first time. "Your Honor, the HOA was acting in good faith based on the information available to them. Good faith doesn't override property rights, counsel. Do you dispute the plaintiff's survey?" "We would need time to have our own survey conducted, Your Honor." Judge Holloway leaned back in her chair. "Let me get this straight. The HOA began construction on disputed property without conducting a current survey, and now wants more time to verify boundaries after the fact? Is that your position?" The silence in the
courtroom was deafening. "Your Honor," Pemberton said carefully, "we request a continuance to properly assess the boundary situation." Request denied. The time to assess boundaries was before you started digging. Counsel for the plaintiff, please continue. Jennifer presented our entire case methodically and devastatingly. The property evidence, 3 surveys, all confirming my ownership, the trespass, photos and witness testimony of the construction, the harassment campaign, Every violation notice, time-stamped, and documented the discriminatory enforcement. My photos showing identical violations at other homes, including HOA board members' properties, with zero enforcement by the time Jennifer finished. Even I was impressed. She'd built an airtight case. But the moment that really sealed it was when she called me to the stand. "Mr. Morrison," Jennifer asked, "can you describe how this situation has affected you and your family?" I took a deep breath. "Your Honor, my wife and I bought our home because we wanted to raise our kids in a safe, friendly community. We've been good neighbors. We've paid our dues, followed the rules, and volunteered for community events. When I discovered the construction, I didn't immediately threaten legal action. I tried to communicate with the HOA. I tried to resolve this reasonably." I glanced at Karen in the gallery. She was staring at her hands. Instead of admitting a mistake and working with us, the HOA launched what can only be described as a campaign of retaliation. They try to fine us thousands of dollars for violations they don't enforce against anyone else. They've threatened to revoke our access to amenities we've paid for. They've made our home, our sanctuary, feel like a battleground. My voice cracked slightly. "We have 2 young kids, Your Honor. Our daughter asked me last week why the neighbors don't like us anymore. How do you explain to a
7-year-old that some adults abuse power instead of admitting when they're wrong?" The courtroom was silent. Judge Holloway made some notes, then addressed both parties. "I'm going to issue my ruling from the bench. This case is straightforward, despite attempts to complicate it." She looked directly at the HOA's legal team. "First, regarding the property dispute. The plaintiff has provided clear, documented evidence of ownership. The defendant has provided generalized easement language from a 30-year-old development plan with no specific survey data. The land in question is Mr. Morrison's private property. The HOA had no right to build there, period." Pemberton started to object, but Judge Holloway held up her hand. "Second, regarding the harassment and discriminatory enforcement. The evidence presented shows a clear pattern of retaliation against the plaintiff for exercising his legal rights. The violation notices, the selective enforcement, the threats, all of it demonstrates an abuse of HOA authority that this court will not tolerate." She paused, letting that sink in. "Here's my order. The HOA is to immediately cease all construction on the disputed property. Any structures already built are to be removed within 30 days at the HOA's expense. The property is to be restored to its original condition, including professional landscaping to match the surrounding area." Karen visibly flinched in the gallery. "Furthermore, all violation notices and fines issued to Mr. Morrison in the past 3 months are hereby voided. The HOA is ordered to pay Mr. Morrison's legal fees, which counsel will submit for review. And finally, and this is important, I'm ordering the HOA to implement a comprehensive review of their enforcement policies with an independent third party to ensure this kind of discriminatory behavior doesn't happen again." She looked at me. "Mr. Morrison, I'm sorry you had to go through this. No homeowner should be bullied by their own."
Wah. Then she slammed her gavel. "We're adjourned." The weeks following the court decision were surreal. The construction equipment disappeared from my property within 48 hours. The HOA hired a professional landscaping company to restore my backyard. They didn't just fix what they destroyed, they actually improved it. New sod, a beautiful flower bed, even a small decorative fountain as a gesture of goodwill. The legal fees awarded by the judge totaled $47,000. Jennifer had warned me that getting an HOA to actually pay a judgment could take months of additional legal wrangling. But to my surprise, the check arrived within 3 weeks. But the real changes in Riverside Estates went deeper than landscaping and checks. 2 weeks after the ruling, I received a letter not from the HOA office, but from Karen personally. "David and Sarah, I owe you both an enormous apology. I let my position on the HOA board cloud my judgment, and I allowed the organization to bully you instead of doing what was right. There's no excuse for my behavior, and I understand if you can't forgive me. What happened to you opened my eyes to how our HOA has been operating. I've resigned from the board, and I'm working with several other residents to completely overhaul how we do things. I hope someday we can be neighbors again, in the truest sense of the word." Karen and I showed the letter to Sarah. "What do you think?" She was quiet for a moment. I think people make mistakes. Big ones sometimes. The question is whether they learn from them. 3 days later, there was a knock on our door. It was Karen, holding a homemade lasagna and looking genuinely nervous. I know a casserole doesn't fix anything, she said quickly, but I wanted you to know I meant what I wrote. And I wanted to tell you in person that there's going to be a special community meeting next week about HOA reform. I was hoping you might be willing to attend. Your voice, your experience, it matters. Sarah.
Then I stepped aside. Kumain. Let's talk. The community meeting the following Tuesday was unlike any HOA gathering I'd ever attended. Usually, these things drew maybe a dozen bored retirees. This time the clubhouse was packed. Over 200 residents showed up. Karen opened the meeting. Most of you know what happened with the Morrison family. What you might not know is that our HOA has been operating with virtually no oversight or accountability for years. I was part of the problem. Tonight, we're here to become part of the solution. She introduced a consultant named Dr. Patricia Williams, who specialized in HOA governance reform. Dr. Williams didn't pull punches. I've reviewed Riverside Estates bylaws, enforcement records, and financial statements, she said. What I found is disturbing but unfortunately not uncommon. Your HOA has been functioning more like a fiefdom than a community organization. Selective enforcement, unclear policies, inadequate financial transparency, and virtually no mechanism for residents to challenge board decisions. She clicked through a presentation showing examples, many of them involving me, but also several other residents who'd been quietly penalized over the years. The good news, Dr. Williams continued, is that all of this can be fixed. It requires commitment, transparency, and a willingness to put community above ego. Are you willing to do that? The response was overwhelming. Residents started volunteering immediately. An attorney offered to help rewrite the bylaws pro bono. An accountant volunteered to audit the HOA's finances. A retired teacher offered to create educational materials about homeowner rights. By the end of the meeting, Riverside Estates had formed 5 working committees dedicated to reforming different aspects of HOA governance. And they asked me to chair the Enforcement Oversight Committee. 6 months after the lawsuit, Riverside Estates was a different place. The new bylaws we implemented included
Transparent enforcement standards, clear, written criteria for all violations, mandatory photographic documentation, a public database showing all enforcement actions, with addresses redacted for privacy, quarterly reports on enforcement patterns too, homeowner protections, right to appeal, any violation with an independent arbiter, mandatory cooling-off period before fines can be assessed, caps on daily fines to prevent excessive penalties, whistleblower protections for reporting HOA abuse. 3. Board accountability, term limits for all board positions, mandatory training on property rights and fair housing, regular community forums for feedback, financial audits by independent third parties. 4. Conflict resolution, mediation requirements before legal action, community ombudsman program, anonymous suggestion box with mandatory board review. But the most important change wasn't in the bylaws, it was in the culture. The new playground, when it was finally built, was constructed on actual common space after a proper survey. The HOA invited every family to a ribbon-cutting ceremony. Our daughter was one of the kids chosen to cut the ribbon. "Daddy," she asked as we walked to the playground that day, "are the neighbors our friends again?" I looked around at the smiling faces, the kids running and playing, the community coming together. "Yeah, sweetheart, I think they are." Karen approached us, her own kids in tow. "Thank you for coming. And thank you for not giving up on this community. Thank you for being willing to change," Sarah replied. And she meant it. Looking back on this whole experience, I learned some crucial lessons that anyone dealing with an HOA or any organization with power over you needs to understand. Lesson 1. Document everything from the moment the excavator showed up. I photographed, recorded, and saved every
interaction. Those documents won my case. In any dispute, contemporaneous documentation is your most powerful weapon. Lesson 2. Know your rights. I'm ashamed to admit that I'd never actually read my property deed thoroughly before this happened. I'd never reviewed the HOA bylaws carefully. I assumed everything was fine because it had always been fine. That was a mistake. Know what you own and what rights you have. Lesson 3. Don't fight alone. I couldn't have one without Jennifer. Whether it's a lawyer, an advocacy group, or a community organizing effort, you need allies. No one successfully fights an institution by themselves. Lesson 4. Bullies rely on your silence. The HOA assumed I'd back down when they started the harassment campaign. They thought the violation notices and threats would make me give up. Standing firm, documenting their behavior, and exposing it in court turned their tactics against them. Lesson 5. Change is possible. I went into this thinking the only solution was moving away from Riverside Estates. Instead, we transformed our community into something better than it was before. Sometimes the hardest path leads to the best outcome. Lesson 6. People can surprise you. Karen went from threatening me to becoming one of the strongest advocates for reform. People aren't always defined by their worst moments. Sometimes they're defined by what they do after those moments. It's been a year now since that excavator showed up in my backyard. Our garden is more beautiful than ever. The neighborhood playground is always full of happy kids. And our HOA board just won an award from the State Homeowners Association for excellence in community governance. We didn't just win a legal battle. We rebuilt trust. We created accountability. We proved that even when institutions fail, people can come together and make things right. But I want to be clear about something. This had a happy ending because I had
Resources. I could afford an attorney. I had the time and energy to document everything. I had the support of my wife and eventually my community. Not everyone in an HOA dispute has those advantages. If you're watching this because you're in a fight with your HOA, here's my advice. First, check if your state has an HOA ombudsman or regulatory agency. Many do, and they can provide free assistance. Second, look for legal aid organizations that handle housing disputes. Some will take HOA cases pro bono or at reduced rates. Third, connect with other homeowners in your community. Chances are, if the HOA is abusing power against you, you're not the only victim. There's strength in numbers. Fourth, document everything. I can't stress this enough. Every email, every letter, every conversation. Build your case from day one. And finally, don't let them make you feel powerless. HOAs have authority, but they're not above the law. Property rights are fundamental. You have the right to defend what's yours. This is Neighbor Wars HQ, where we expose the truth about property battles and help you understand your rights when neighbors, HOAs, or anyone else tries to push you around. If this story resonated with you, do me 3 favors. First, smash that subscribe button and turn on notifications. We publish new property battle stories every week, and you don't want to miss them. Second, drop a comment below. Have you dealt with an HOA nightmare? Are you fighting one right now? Share your story. This community supports each other, and your experience might help someone else. Third, share this video with anyone who's buying a home or dealing with an HOA. Knowledge is power, and the more people understand their rights, the harder it is for these organizations to abuse them. Coming up next week, my neighbor stole my driveway, the shocking footage that proved it.
You won't believe how that one ended. Until then, know your rights, document everything, and never let anyone push you off your property. This is Neighbor Wars HQ reminding you, your property, your rules.